And today, the Supreme Court has answered that question by a vote of 6-3.
The U.S. Supreme Court has just issued a major ruling.
Major Second Amendment case.
Major Supreme Court ruling.
The Supreme Court has issued multiple understated, yet consequential rulings that may determine the destiny of the AR-15, concealed carry protections, and the Second Amendment as a whole. This transcends mere legal procedure. This is the nation's highest tribunal delivering a statement. Certain petitions were rejected, others were accepted, but the comprehensive picture is crystallizing unmistakably. The court is choosing its confrontations strategically and establishing boundaries that could upend every state statute from one coast to the other. This breakdown is your complete analysis of the most substantial legal shifts impacting firearm protections in 2026. Whether you carry daily, possess an AR-15, or stand behind the right to keep and bear arms, this intelligence is essential, and the more educated you become, the better positioned you'll be to defend your constitutional freedoms. Before we proceed, please subscribe to Law Advisor and activate notifications. We examine every significant Second Amendment case and legal development the moment it unfolds, ensuring you're never uninformed when your rights are at stake. Let's analyze it all. Chapter 1. 4 cases. Determining the future. 4 pivotal Supreme Court cases are reshaping the landscape of gun freedoms in America. Each of these legal challenges involves a separate aspect of the Second Amendment framework, and collectively they establish what hangs in the balance in 2026. These aren't isolated regional disputes. They represent national-scale legal confrontations with the capacity to transform how the Constitution gets interpreted throughout all 50 states. Let's examine them individually so you comprehend their weight. Snope versus Brown challenges California's so-called assault weapon prohibition, including the AR-15. Ocean State Tactical versus Rhode Island contests the 10-round magazine restriction. Wolford versus Lopez assaults Hawaii's registration and licensing requirements for firearms. United States versus Hamani examines what constitutes a prohibited individual in federal criminal law. Each case scrutinizes a distinct component of the Second Amendment under examination. Combined, they reveal how severely fractured the appellate courts remain, even following the Supreme Court's Bruin precedent. This carries significance because the court utilizes these legal splits as rationale to intervene or refrain. These aren't merely legal disputes. They're confrontations over how much authority government should possess over what you can possess, how you transport, and whether the Second Amendment still represents what it was initially drafted to safeguard. Chapter 2. Supreme Court rejects AR-15, Prohibition Challenge. In a surprising development, the Supreme Court chose not to accept Snope versus Brown. This means California's prohibition on AR-15 pattern rifles will persist for the present. Despite millions of Americans asserting these firearms are unmistakably protected under the Constitution, the petition was regarded as the most straightforward assault on so-called assault weapon prohibitions since the Bruin judgment, yet the court declined it. This rejection sent shockwaves through the Second Amendment community. California's statute prohibits an extensive range of semi-automatic rifles employed by law-abiding citizens. The petition demonstrated clear discord between the Ninth Circuit's determination and the Bruin precedent. Gun rights organizations had anticipated the court would intervene and remedy this appellate court defiance, but the court declined, at least temporarily, opting not to grant certiorari. This doesn't suggest the Supreme Court endorses California's statute. In reality, some theorize the court is awaiting a petition with a more substantial factual foundation or enhanced legal precision. Others contend the justices prefer addressing magazine prohibitions or licensing complications first before confronting semi-automatic rifles. Regardless of reasoning, this represented a squandered opportunity for immediate clarification. And presently, California's AR-15 prohibition endures, abandoning millions of gun owners without federal remedy. Chapter 3. Magazine restrictions could spark the next major confrontation. While the court rejected the AR-15 petition, attention is now pivoting to the challenge against magazine prohibitions, specifically the litigation Ocean State Tactical versus Rhode Island. This lawsuit interrogates the constitutionality of limiting magazine capacity to merely 10 rounds. Gun rights advocates contend that these magazines are commonly possessed and extensively employed, rendering them clearly protected under the Second Amendment. And presently, this case may become the vehicle the court utilizes to establish its position. The Rhode Island statute prohibits possession of magazines containing more than 10 rounds. Millions of Americans already possess these magazines for legitimate self-protection. The case directly challenges the common use benchmark outlined in prior decisions. The justices demanded a comprehensive response from the state, indicating substantial interest. That closing detail is crucial. When the court requests a response rather than dismissing a petition immediately, it signifies at least one justice is earnestly evaluating whether to grant review. If accepted, this case could become the most consequential gun rights confrontation since Bruin, with capacity to invalidate magazine prohibitions in every jurisdiction where they are implemented. Chapter 4. Hawaii's firearm licensing statutes under constitutional attack. The third case receiving scrutiny is Wolford v. Lopez, challenging Hawaii's rigorous firearms licensing and registration mandates. In Hawaii, residents must navigate multiple tiers of governmental oversight merely to lawfully possess or carry a firearm. The state's comprehensive framework was constructed on discretionary authorization, something directly contradicting the shall issue benchmark clarified by Bruin. Now the court is being petitioned to address it. Hawaii's framework demands licenses, registration, and multiple authorizations for possession. Municipal authorities held nearly absolute control over whether citizens could acquire firearms. The Bruin decision mandated objective standards, not subjective discretion. Wolford v. Lopez pressures the court to determine whether Hawaii's framework breaches that benchmark. What renders this case even more substantial is Hawaii has declined to reform its statutes consistent with Supreme Court precedent. This establishes a showdown, and the court could leverage this case to strengthen Bruin and dismantle licensing arrangements that continue operating as though precedent never existed. This transcends Hawaii alone. If the court rules expansively, every state with comparable restrictions could face mandatory immediate rollback. Chapter 5. Federal gun prohibition. Could face major overhaul. Among the most quietly influential cases now on the court's docket is United States v. Hamani, which contests the federal statute prohibiting all convicted felons from possessing firearms, even when their offenses were nonviolent and occurred decades previously. This case penetrates the essence of what the Second Amendment safeguards, and whether perpetual gun prohibitions are constitutional absent clear historical foundation. It's an examination of justice, proportionality, and constitutional integrity. Hamani was convicted of a nonviolent tax violation and forfeited his gun freedoms permanently. The court's Bruin benchmark demands historical tradition, not merely governmental rationale. Appellate courts are now fragmented on whether all felon in possession prohibitions are warranted. If SCOTUS intercedes, it could terminate blanket perpetual bans for nonviolent offenders. This marks a significant watershed moment. If the court consents to hear the petition, it could reinstate gun freedoms to millions of Americans who committed nonviolent offenses previously but have subsequently maintained lawful existence. The result could reconstruct the parameters of the Second Amendment in ways we haven't witnessed in generations. Chapter 6. Why this Supreme Court session could transform everything. What distinguishes this Supreme Court session is the sheer quantity of Second Amendment petitions queued and the court's continuous indicators that it hasn't finished restructuring gun jurisprudence in America. From AR-15s to magazines to licenses and felon freedoms, every dimension of the controversy is now one decision away from a potential coast-to-coast determination. And the trajectory is unmistakable. Examination is intensifying on states and enforcement bodies. SCOTUS has already established precedent with Bruin and Caniglia versus Strom. Multiple petitions were refused review, but others garnered serious consideration. The court's restraint can be calculated anticipating the optimal vehicle. Conservative justices may be establishing foundation for a comprehensive transformation. The critical question now isn't whether the court will address gun freedoms again, but when and how emphatically. With multiple cases, just a vote or two from complete review, we could be transitioning into a fresh phase where the Second Amendment obtains the most robust judicial safeguarding in contemporary history. Prepare for what's approaching. As the Supreme Court continues evaluating critical firearm petitions, one reality is undeniable. The struggle over the Second Amendment is nowhere near concluded. Actually, it may be entering its most consequential period yet. Whether concerning AR-15s, magazines, licenses, or rights restoration, the legal battlefield remains active and the implications are more substantial than ever. If you value gun freedoms, due process, and constitutional liberty, now is the moment to stay educated, watchful, and involved. Every single determination emerging from this session could transform the equilibrium of authority between the citizenry and the government. Ensure you're subscribed to Law Advisor so you never overlook a single legal development, critical determination, or transformative advancement in the realm of gun freedoms. We analyze it all with precision, accuracy, and immediacy. Hit that like button, distribute this breakdown, and prepare. Because the next Supreme Court action could alter everything.